All right, new unit here. This is my favorite unit since I do consulting on human resources. So first two chapters in this unit, we're going to talk about agency. And agency tends to be a function within the employment law. And then we're going to talk about employment law. Unfortunately, we do not have just tons of time. So, I'd love to do it. I actually, in my previous university, every spring taught a course just on employment law, and that was a lot of fun for me. And we covered a lot of different topics. But let's talk about agency. And when you think about agency, what's the most common thing you think of when I say agent?
Insurance agent.
Insurance agent, some other agents. That's an excellent one, of course. Others?
Someone who works for the company, like an employer?
Well, we're going to get to employees. Employees may or may not be agents depending on their legally defined responsibilities. Is one of the points of this. But yeah, insurance agents, real estate agents, basically people that act for us. Obviously, insurance agent obtains insurance for us because of licensing and other issues. It's very hard to buy insurance, without going through an agent. So I buy it online now. You're buying it online through an agent. It's just there somewhere else instead of sitting next to you. And then in terms of real estate agents, while some of us can't go out and buy houses and buy and sell things on our own, it's a reasonably specialized area. It's a little bit more challenging for a lot of people, and it's such a large purchase. A lot of people feel that it's certainly worth it to use an agent, especially an experienced real estate agent. One of the things to keep in mind, though, is that another reason why it tends to work in real estate is because the buyer tends not to realize the payment of the fee, because the fees are generally paid by the seller. So it tends to be a hidden cost, whereas if the buyer is paying the commission, then it becomes something different. So kind of interesting. Bless you. How that works. So the agent is a fiduciary relationship with the principal and tries to get things done. One of the things that we have out there, I think we mentioned restatement of torts. And we have law professors and practitioners get together and develop these encyclopedias of sorts that develop an approach to things. And so in a lot of legal articles and stuff like that, we talk about restatement of torts, restatement agency. This is already in its complete second edition. These things have been around for decades. But today, because of the way the law is developed, we've kind of moved past that into real codification, and tends to make these less cited, maybe larger articles include, but as business people, we very rarely today consult a restatement. So just so you know, when you see it up here, yep, it's a legitimate area of analysis, but that's not what we usually do in practical law. I've been practicing law, this is my 39th year of law practice. I have never said to a client, oh, well, in restatement of agency or restatement of torts, this is what happened. Never happened, because that's not how business law really happens. Okay? But again, in fact, I've written a number of law review articles we've never used in a law review article. Anyway, just so you know why it's there. In agency, we've got the principal is the person who wants something done. The agent is the person acting on your behalf as the principal. And then you have the third party, which may be the real estate agent on the other side and the seller on the other side as you're representing the buyer, and so forth. So agency, fairly fundamental concept, very common. Now, not genius at work here, but you either have a fully disclosed principal, partially disclosed principal, or an undisclosed principal. Gee, you could never figure that out without this textbook, right? But let's talk about undisclosed principal. That's the most interesting one. Okay, you have decided to build the next great skyscraper in New York City. You've got lots of money to burn, and what's going to happen if you start buying a city block to build a skyscraper.
Prices go up.
Prices go up. Each time you buy one, as soon as somebody figures out that you're trying to buy a whole city block, how high will it get at the end?
As high as you pay.
Really high, yeah, yeah. So a way to do this is kind of slick, and this is documented. I can't remember how long ago this was, whether it's 10 or 15 years ago. I know it was before 911, but I don't know exactly what happened. But there's actually an article or a story out there, book out there, about a group that got together and bought a city block in New York. And I think they ultimately set up 200 different companies to acquire each of the pieces without tipping anybody off that that's what they were doing. And that's undisclosed principal on about 3 levels. And then they put it all together. There's nothing illegal about that, okay, just so we're clear, or unethical. I mean, it just makes sense because they paid what the market was, but it takes a lot of effort, but you're dealing with big dollars. I mean, these are really big transactions to make something like that happen. So, normally we deal with the disclosed principle. You're going to buy a house, you say to the real estate agent, I'm looking for a 3-bedroom, 2.5-bath house. I'm looking for it in this neighborhood. You're the buyer. Contract goes in. It's got Mr. and Mrs. John Smith on the contract. No, nothing hidden. On the seller side, usually it has the sellers, Mr. and Mrs. Jones. You know, it's always pretty clear, most real estate contracts. Now, if the person is an estate selling it, it may say the estate of Harry Smith or something like that. But usually you know who the seller is and who the buyer is for real. Now, occasionally somebody will be told, and a lot of this tends to sound scamish, you know, these people that, you know, we buy cheap houses and all that jazz. And they go out and say, well, I'm really buying the house for somebody else, but I don't want to tell you who it is, but, you know, I think I can get the money, and, you know, they go through all of this stuff. So, not as exciting, but it tends to be how things operate out there. Now, what we want to focus on is the authority of the agent. So, generally speaking, people have either general authority or they have specific authority. With very rare exception, people have specific authority. So, like I could be in town for a closing that was involving some real estate agents. So I actually signed the power of attorney so my real estate agent could go and sign the closing papers. Now today we don't do that. That was, you know, quite a while back. Today we FedEx the paperwork. So I sign it today, I FedEx it to them, so I sign all the stuff. But the agent only had the responsibility to sign that paperwork on that one closing on that one day. It's pretty straightforward. Now, general agency, what you might have is you have a person, like my dear friend who's missing right now, is if a person's not with the program, you may have a guardian appointed. Well, a guardian is actually a special form of a general agent. The guardian is empowered to act pretty much across the board in the best interest of the person they're taking care of. And a lot of times, as you know, that's going to be a minor, or it's going to be an adult who has limited capacity for some reason. So a lot of different circumstances there. You can have several different powers. Let me answer that question. I can't remember if we've done it in this class. Power of attorney is a very common way to designate an agency. Again, it can be limited or it can be general. Where people sometimes get confused is a durable power of attorney versus a regular power of attorney. A regular power of attorney expires with the disability of the person. Durable power of attorney is much more valuable to aging circumstances. I'll give you an example. A dear friend of mine actually called me today, so that gets called tomorrow morning. Her husband suffered a stroke 2.5 years ago. Fortunately, they each had reciprocal durable powers of attorney. So even though he's disabled, because it's a durable power of attorney, it's still valid, and so she can conduct his affairs. Absolutely, yeah, because the person's already disabled. If it's not a durable power of attorney, then you got a gap, and if they've got a spouse, you may be okay. But if it's the children or family, but not the spouse, you get into all sorts of issues. Yeah, it's a very challenging area, and it's a shame because a lot of people are doing stuff off the internet today, and they're not really getting all the information they need for things like living wills and stuff like that. Okay, let's talk about how you create an agency. I want to come back to real estate agents. In Texas, we have a state statute that says the following. If you are expecting to get a commission, you must A, be licensed, and B, your commission agreement must be in writing. That's Texas state law. That's statutory. Only a person with a broker's license may accept a commission. And you say, well, what about sales agents? A sales agent can only get a commission from their broker or from another broker with permission of their broker. That's it. It's the only way a licensed salesperson can get a commission. State law. But it mirrors basic agency concepts. So the broker is the principal responsible for their sales agent, who in turn are acting as agents for the homeowners and the home buyers out there. And the people leasing also are being represented in those capacities. So very important to keep this in mind. Okay? So let's proceed with that. On the commission, it's a no-cut deal. If you do not have a written commission agreement, you cannot collect a commission even if you're a licensed agent. So, generally speaking, and again, the flexibility of the real estate people is way cranked down, because by defining almost every change as an unauthorized practice of law, makes it a very difficult situation in terms of their changing what they're doing. Do you have a question? Now, what do agents owe their principal? Duty of loyalty. You can't go against your person. You can't go around them. You can't steal from them. You have to protect confidential information. You have to do what you're supposed to do. If they ask you to go do something, that's what you're supposed to do. You got to keep your principal informed. You must act in a competent manner, within reason, and always a duty to account. If you're handling money, you duty to account. Where we see this is not so much in buy-sell transactions, but where real estate agents are helping lease a house, in handling rental arrangements and stuff like that, collecting rents, handling maintenance costs and stuff like that. Very important that those agents act responsibly and are always able to account for the money in there. And that brings in additional laws, state laws that regulate real estate agents, because it is an area, again, a great deal of finances are involved, and the risk of abuse is significant. Now, what does the principal owe the agent? Duty to pay compensation. They don't work for free. Define what it is, you gotta pay them. No problem there. Reimburse the agent for authorized expenses, and indemnify if the agent gets sued because of their actions on behalf of the principal, as long as they're within the scope of their agency. Termination of agency. This is hard. Insanity of the principal or agent causes automatic termination, or if the house is destroyed that you've put a contract in, stuff like that. And bankruptcy. Certainly, you can just put this across the board. You can always mutually agree to change something. That's not too hard. Unilateral action, this is a little bit more difficult. This usually involves a breach by the other side. So in other words, you're a real estate person, you're helping somebody lease their house. The homeowner steps in, starts collecting the rent directly, doesn't pay you your share, but you have a one-year contract that parallels the one-year lease you obtained for the homeowner. Well, they're in breach of the agreement, therefore you can declare a breach, say, I'm not doing any more work for you, but I expect to get paid what I'm supposed to get paid. So that's where you might see a circumstance like that.